the trial, and pretrial. Pretrial conferences or evidentiary hearing. A pretrial conference or evidentiary hearing is where the court decides what evidence and witnesses can be submitted at trial. A pretrial conference or evidentiary hearing is where the court decides what evidence and witnesses can be submitted at trial. Just because you file the evidence, it means nothing if the evidence is not verbally stated during the hearing or trial. The witness will probably have to be at the pretrial conference or evidentiary hearing and provide testimony. Thus, send the witness a notice like the one in video 10, Student Loans and Preparing for Trial. Your witness will also have to come to trial and provide testimony. Thus, you will have to send the witness another notice. Please see video 10, Student Loans and Preparing for Trial, regarding the procedure on how to provide the witness a notice. The pretrial conference or evidentiary hearing is also where the court will tell the parties if the briefs are needed before trial. Remember, a brief is very important because it allows you to provide testimony and evidence you might not be able to provide at trial. Remember, at this hearing, the judge might say that she has been fully briefed, so there is no reason to write a brief. This is a trick the judge is using to kill your case. Therefore, always request to write a brief. The other side's lawyer will do everything they can to keep any evidence that may help your case out of trial. This includes the Department of Justice. Always remember, a trial is not about the truth, it's about winning. The other side's lawyers are here for one reason, and that is to make sure you do not get a discharge. This is what they're getting paid to do. If it was about the truth, then the other side's lawyers would not have objected to you getting a discharge, and all of this would have been over months ago. The other side's lawyer will say that the evidence you want to submit is not relevant, too old, or was not conducted by the right kind of professional. Your answer will be, according to Rule 401, any evidence that can make a fact more probable than it would be without it is relevant. What I am trying to show the court is a complete picture of why I deserve a discharge on my student loans. According to Rule 902, the articles I have from online newspapers and periodicals describes the kind of disability or the medical condition I have and the effects it can have on a person. These articles show that my disability is something you are born with and never goes away, or shows that this kind of medical condition I have gets worse over time and does not improve with time or treatment. According to Rule 8034, my neuropsychological assessment was made for medical diagnosis or treatment. It describes my medical history when it comes to my disability and the inception of my disability. Plus, it also describes some of my employment history. Since my disability is something you are born with and never goes away, the neuropsychological assessment indicates that this will never change. The printout I received from Social Security of my lifetime earnings show the year my income decreased, or that I've never been able to attain reasonable employment. The letter I received from the Student Loan Servicer Company shows that the accumulated interest and outstanding principal are now so high that I will never be able to pay off my student loans given my current income. Therefore, when you combine the articles, my neuropsychological assessment, and my medical condition, and my lifetime earnings from Social Security, one gets a better understanding about my life and why I'm requesting a discharge, and why this situation will not change in the future. The judge should write an order regarding what evidence and what witnesses can be submitted at trial. If the judge does not write an order, then all the evidence you have can be submitted at trial, and your witnesses are not limited to what they can or cannot say at trial. The trial. If you have no witnesses at trial, then you will be the only one testifying. Remember that you requested accommodations for your disability of reading from your notes or documents. Before you start, verbally list all the evidence you will be stating during your testimony. Before you start, verbally list all the evidence you will be stating. For example, I will be using the following evidence to help with my testimony. Then give a list of the evidence: medical records, doctor's letters, Social Security printout of lifetime earnings, student loan amounts from loan servicer companies, etc. Then tell your story and inject the evidence into your story. Remember, you are trying to prove 3 things. Prong 1. You cannot, based on current income and expenses, maintain a minimal standard of living for yourself and your dependents if forced to repay the loans. Prong 2. Additional circumstances exist indicating that this state is likely to persist for a significant portion of the repayment period of the student loans. Prong 3, that the debtor has made good faith efforts to repay the loans. Inject the evidence the judge said that you cannot submit into your story. Why? Because you want as many rulings on the evidence on paper as you can get. You do not want only a verbal ruling. This is important because when the appeals court looks at the transcripts of your testimony, they might say that the evidence should have been allowed because it is relevant in providing a full picture of your story. For example, I started college in 1991 and knew that something was wrong, so I asked and received a neuropsychological assessment. For my 1991 neuropsychological assessment, I was diagnosed with a learning disability. It was recommended that I receive books on tape, text-to-speech readers, etc. Now, you must inject evidence the judge said you could not. The other side's lawyer will have a problem objecting to it because you stated the magical words, "you received." After college in 1997, I interviewed with Microsoft in Seattle, IBM in Chicago, etc. As you can see from my lifetime earnings from Social Security, I was never able to attain a professional position, and thus never had the money to make a monthly payment. For my pay stubs, I currently do not make enough to make a monthly payment on my loans. You just use your employment history, lifetime earnings from Social Security, and pay stubs to help prove Prong 1 and Prong 3. Prong 1. You cannot, based on current income and expenses, maintain a minimal standard of living for yourself and your dependents if forced to repay the loans. Prong 3. That the debtor has made good faith efforts to repay the loans. The hardest one to prove is Prong 2. Your medical records, the articles, your neuropsychological assessment, employment history will help to prove Prong 2. For example, for the past 5 years, I have applied for the following jobs. Give the dates, the job title, and job description. Because of my disability for my neuropsychological assessment, I lose focus, have speech issues, etc. This is where the other side's lawyer will object. This is still good because you were able to verbally state the evidence, which means you now have something that the Court of Appeals can consider. For my lifetime earnings from Social Security, I have never been able to attain a position that paid enough for me to make minimal monthly payments on my loans. Unless someone can tell me what more I can do, I have tried everything I can think of. Remember to make sure that all your evidence is filed. Make sure the other side has a copy of all of your evidence. And make sure you verbally state all your evidence at trial. Remember, your testimony is very important. Everything hinges on your testimony. If you reviewed all the videos, then you are now more prepared than most. Now you know that you cannot just go to court, tell the truth, and think that your student loans will be discharged. Now you know that it's not about proving that you deserve a discharge. It is about going to court and taking away any reason not to give you a discharge. We know it all seems overwhelming, but it is not. Most that file bankruptcy on their student loans do it without a lawyer. If they can do it, so can you. Once you start, you will find that you will have more than enough time to accomplish it all. We know these videos have been long, and we thank you for your time and consideration. Good luck. Best of luck.